Well, a very, very good afternoon, everyone. It's 12:30 and I think we'll get started. My name's David Little and I'm delighted to welcome you to this webinar today, Keeping Conflicts Out of Court or Why Life is Too Short to Litigate. This is a joint webinar between a number of organisations. I'll introduce those to you shortly, but just to let you know who I am, my name is David Little. I'm the Chief Executive and the founder of a fantastic organisation called the TCM Group. We provide mediation, dispute resolution, leadership and collaborative consultancy for organisations across the UK and overseas, and we help organisations embed a culture of constructive, collaborative and compassionate dispute resolution within their organisations. I've seen firsthand the challenges that can come about when people get into a litigation mindset, and I often find litigation isn't just a process, it's a mindset. And I've seen the power that processes such as mediation can have when the parties adjust their mindset and open their minds to the other party's needs and goals and engage in a dialogue with them. And I'm so excited today to be welcoming a number of people to this session to share their expertise, their experiences and their insights. So this is a joint webinar being run by the TCM Group, by the UK's Mediation Trade Association, the Professional Mediators Association, and by Yes Law, Camilla Palmer, who we'll be hearing from. We also have other speakers, and again, I'll introduce those to you in a moment. So this is a collaborative approach to offer insights and guidance for those of you who are looking at alternative ways of resolving conflicts and disputes within your workplaces, within your organisations. The webinar will last for about 45 minutes. It is being recorded and it will be transcribed and published as a white paper. So we will be publishing this webinar in the next 4 weeks, we would imagine, and that will be a joint publication. So watch this space for that. That will be available for everyone. There are 3 polls through the webinar, and I'll introduce you to each of those as we come to them, and I'd love to invite you to participate in those polls and share some of your experiences, good or bad, of litigation in your experiences. Now, one thing is really important. We have some great guest speakers here today, really powerful, experienced guest speakers. We have Camilla from Yes Law, we have Joanna, an employment judge, and of course we have David Parry, a practicing employment lawyer who I've known for many, many years. They are very happy to take questions, as am I. So on your console, you will see there's a box that says questions and chat. If you have a question for any of our speakers, please put it into the questions box. I will be chairing the conversations, so I will make sure that your question is put to the speaker. Now, if unfortunately the speaker is not able to answer your question or there's a technical question, our speakers will look at the questions and come back in writing and put the answers to the questions in the white paper that we publish. So if we don't get a chance to answer your questions today, we will seek to answer them in the published white paper. But please do ask questions. It's a great opportunity to put questions through to some very, very experienced legal professionals, including, as I've mentioned, an employment judge. So those of you who know me and know TCM will know that we've been promoting our resolution, our HR resolution framework now for a number of years. If any of you are interested in looking at our resolution framework, which is an alternative to the traditional grievance, discipline and other HR policies, please let me know. Just send me an email, make contact. I'll be very happy to share that with you. Free of charge, but again, for those of you who've adopted it, and many organisations have adopted the resolution framework that we've been developing at TCM, they've been describing the impact in terms of significant reduction in conflicts, time spent on conflicts, money spent on conflict, and creating the kind of mindset in our organisations where people sit down and have a dialogue with one another. So talking of sitting down and having a dialogue, I hope that you are ready. I hope you can sit back, enjoy. If you're having a sandwich, please do enjoy your lunch whilst you're listening to us. And as I mentioned, it is being recorded, and we will put this up onto YouTube and to our various websites. So if you miss anything, you can listen again at your leisure, or of course you can share with your colleagues, with your partners, with your friends, with your family, or anybody else who you know who might have an interest in finding alternative systems and approaches for handling conflicts and disputes within your organisation. So a little bit about TCM. TCM empowers people and organisations to adopt new and innovative approaches to disputes and conflicts. Our focus is on pulling the unions, the HR professionals and leaders and managers together to pull together and to create effective systems and processes that drive a person-centered and values-based approach to conflict management and dispute resolution. And when I talk about person-centered and values-based, I'm talking about dialogue. And my experience as a mediator for some 30 years, and I've mediated in some incredibly tough situations here in the UK and overseas, my experience as a mediator has taught me that whilst not every case is suitable for mediation, although a great many are, is that when the parties in a difficult conflict situation have the courage, and it takes real courage, real guts, but have the courage to sit down with one another, amazing things can happen. And my experience, my personal experience of litigation, whether it's in a quasi-judicial policy framework within our organisations or through a more formal litigation process, is it impedes the mindset and impedes the instinct to sit down with the other person. We become polarised. And my experience is that when we can break that and change that and give people an alternative, it can be incredibly powerful. And mediation as an approach is one of the most powerful, transformative, engaging, incredible processes that I've ever seen. And it gives me great privilege to work with people in conflict. But one of my biggest frustrations as a mediator is that perhaps more widely across society, and perhaps looking at the legal profession as well, is we're not encouraging people to take a collaborative mindset. So the TCM group, and of course the Professional Mediators Association, of which I'm proud to be the current president of the PMA, are organisations who are there to promote alternative dispute resolution and in particular mediation. And the PMA drives up standards. We have some coherent and outstanding professional standards. We run continuing professional development events for our members, and that might be ranging from mental health issues and tackling those within mediation, social psychology, hostage negotiation. We have some wonderful CPD events. The PMA offers an accreditation scheme. It's the only independent accreditation scheme in the UK for mediators, where mediators apply to the PMA, a not-for-profit independent organisation, to become accredited members of the PMA, and it's the only approach within the UK where mediators will be able to call themselves accredited mediators. We offer the National Mediation Award, and we have over 1,500 members, by the way, in the PMA. It's a fast-growing, fast-paced organisation. So the National Mediation Awards are an opportunity to promote and celebrate best practice in mediation, and we offer regular newsletters and events such as today's webinar. And by the way, it's free to join the PMA. So if you're not a member of the PMA and you're interested, please go to professionalmediator.org and submit your application, your free application, to become an associate member. It's as simple as that. So if you're not a member, then please, I would urge you do join the organisation. Here's a few of the organisations that I've personally worked with and my team have worked with at TCM to embed a progressive approach to dispute resolution. And these are some of our more recent organisations. For those of you, again, who know TCM, we've been running the Royal Mail's Industrial Relations and Bullying and Harassment Mediation Programme, and now we've moved that as a fully internal mediation programme. We've trained up over 50 mediators within Network Rail. HSBC, we've been training their entire employee relations team within HSBC in mediation skills. Their employee relations team now describe themselves as employee relations specialists and accredited mediators. HSBC has placed mediation at the heart of its employee relations strategy, recognising the damage of litigation and litigation type processes. And there's a number of other organisations. HM Revenue and Customs is a really interesting example of how we've worked with an organisation to embed mediation into their litigation and settlement strategy. The tax disputes tribunal are introducing fees through 2017, and HMRC were keen to avoid the unnecessary need for people to go to tribunal, and have embedded ADR and mediation across HMRC to promote an earlier and more collaborative resolution of tax disputes. It is a massive programme for HMRC, and it's been a real privilege to help that organisation encourage taxpayers in dispute with HMRC to avoid the courts and to get around the table with the help of a skilled third-party mediator. So that's a little bit of background, a little bit about us. For those of you who know us, you'll know we do a lot. For those of you who don't, a very, very warm welcome. So that's me, David Little. I'm going to hand over shortly to Camilla Palmer, QC. She's the founder of Yes Law. I was put in touch with Camilla from one of my clients in a bank in the city. And I sat down, Camilla, you might remember the coffee that we had in Islington, and I was inspired by what Camilla was saying. So it was at that coffee in Islington, we said, look, let's do this webinar. Let's go out and talk about our joint experiences of litigation. And Camilla, I'm sure you'll tell people some of your experiences and some of your war stories, if I can call them that, of litigation, and why you've started to form a view that life is too short to litigate, which of course is the underlying message of your amazing charity that you've established called Yes Law. So I'm very excited, Camilla, in handing over to you shortly. Joanna Wade, we are absolutely privileged to have Joanna joining us. She had to get approval to come and join the webinar, which she got, and we're delighted that we have an employment judge from the Central London Employment Tribunal talking about her own experiences of litigation and mediation and the role that mediation can play and is playing with the Employment Tribunal. So we're really excited, Joanna, to hear you speaking during the webinar. And David Parry is a good friend of mine and someone I've known for many, many years. And David, you might recall we spoke we shared a stage at a conference probably 10-15 years ago now. It feels like a long time. And I remember David saying something along the lines of, if I don't promote mediation to my clients, I'm not acting in their best interests. And I nearly fell off my chair to hear a lawyer using those terms over 10-15 years ago. He is an enlightened lawyer who sees the importance, I think, of collaborative approaches, and he understands the power and importance of litigation. But I'm really excited, David, in hearing you talk a little bit about some of your experiences. As I've mentioned, there will be opportunity for questions and answers. Please do use this as an opportunity to ask any questions that you have. Like I say, we'll try and answer them as we're going along. So a little bit from Michael. Here we are. Look, here, conflict everywhere. Brexit's shown us that. I mean, I knew that. I'm a mediator. I go into organisations and gone into schools and prisons and communities. I knew conflict and division and dysfunction and distress existed. I see it every day. But Brexit in June this year brought it into sharp relief. We can see now that our society, to one extent or another, is divided along various different lines, geography, nationality, age, so on and so forth. So conflict is ubiquitous and has been ubiquitous in any organisation that I've worked with for as long as I've been working with them. However, conflicts, when I see them happening in organisations, whilst we can expect them and they're perfectly natural, and for me a very normal and potentially healthy aspect of our organisations, when we start to talk to the parties in a dispute, this is the kind of language that they start to use very quickly. And unfortunately, the organisation systems and processes and the systems and processes that exist within our society, which I would describe as litigious and quasi-judicial, actually create the kind of mindset which is about winning and losing. It's about blame. It's a breakdown in trust. It's about seeing you in court. It's about getting my pound of flesh, my rights. I've been wronged. I need to have my rights acknowledged. You are a bully. It's about finger pointing. It's your fault. We don't take responsibility. And paradoxically, within our organisations and within society, the very systems and processes that are designed to resolve disputes actually make those disputes worse, because they create the mindset which creates a division and a polarity and a binary black and white approach within the parties. It makes it very difficult to resolve. But as a mediator, I understand that it's not all about black or white. It's about shades of grey. And in those shades of grey, there are emotions, feelings, needs, goals, hopes, fears, aspirations, unmet dreams, unfulfilled promises, feelings of betrayal, fear, anxiety, hurt. And litigation, formal processes identifying blame, evidence, culpability, corroboration and mitigation do not take full account of the grey issues in a conflict. They're black and white. The policy framework is black and white. And we've become obsessed with litigation and process. And the worst excess of these, of course, was set out in the Employment Act in 2004, following the Routes to Resolution white paper. And we saw the introduction of the dispute resolution regulations. For those of you who will remember those, the modified three-step dismissal and grievance procedures were the worst excesses of procedure. I would describe it as procedure gone mad. And it was one of the fastest repeals of legislation in British history. It doesn't surprise me that Michael Gibbons came in and took one look at these policies. He spoke to the TUC, he spoke to the CBI, he spoke to employment judges, He spoke to many others, and everybody said this is not working. It's too procedural. We're losing sight of the real people and the real issues. The challenge I feel that we face within our society is there hasn't been a meaningful alternative offered. We've had some fiddling around the edges, and processes such as early conciliation through ACAS are very welcomed, in my view, as an opportunity to avoid cases going through to employment tribunal and catching them at an early stage. That has to be a good thing. But what messages are being sent out from the UK government, from ACAS, from other key policymakers that promote a mindset within our organisations which is about collaboration, about pulling together? Because litigation and litigation type processes undermine common sense, undermine business relationships, which is, perhaps it's okay. I don't think it's okay. But, if we're trading as part of an EU bloc and all's going relatively well and the economy's functioning relatively well, then perhaps we can just about get away with it. But those things don't exist anymore. We're about to trigger Article 50. We're about to go into tough international trade negotiations. And some of the statistics and figures that we'll see in terms of employee relations and industrial relations in this country are woeful. And for those of you who have to catch a train out of Brighton into London, you're feeling this. And that's just an example of how badly wrong these problems can, how badly wrong it can go. Why aren't people getting around the table? So litigation, in my view, is reactive. It's intrinsically adversarial. And such processes create a culture of fear, of polarization and suppression. And conflict avoidance is one of the most commonly used forms of conflict management that I see when I'm working within organizations. HR unions and management, they're all pulling in different directions. They all have the same interests at heart in one way or another, but they're all pulling in different directions. And unfortunately, litigation or the threat of litigations actually exacerbates these parties all pulling in different directions. Organizations, they often leave it too late. They throw money at the problem, and often that's to a settlement agreement to avoid litigation, when these issues should be resolved much sooner. And I've gone into organisations who've spent more money on a settlement agreement to exit someone from their organisation than they did on spend on training a dozen mediators and 300 managers. One organisation, I trained a dozen mediators, 300 managers, and embedded a mediation scheme for less than the price of their most recent settlement agreement. It's unbelievable, absolutely unbelievable. Yet still we just throw money at these problems. How can organisations argue that that's a good use of their money, whether that's money that could be used for their shareholders, of course, or for driving value for their communities they serve? And litigation addresses the symptoms of the problem. It doesn't get underneath the surface and identify the root cause. And in the root cause is so much learning. And as a mediator, I think the mediation process and other ADR processes is all about learning, about gaining insight. I was at a workshop a masterclass run by Kogan Page, of fantastic publishers, and we were talking in that about managing change and the importance of failure and learning from failure. Well, one of the problems with litigation is it takes failure and hits you over the head with it. And how can we learn from that? And in some respects in organisations, we have to be allowed to fail. But the reason I've described the bogeyman is going to get you is our managers and our leaders, and in some respects our HR professionals, are so scared of failing, they're so fearful of the impact of being taken to court, that we hide or mask the failure, or indeed we don't take risks and we don't take chances. And one of the greatest risks you can take when someone in your organisation is experiencing a conflict or they're not happy is to sit them down in a room and ask them how they feel. And for many managers and leaders, that's the F word of the modern business, feelings. But when we're training managers and leaders, it's the most important thing we say to them to do. It's not rocket science, but we get emails back after we've done training for managers and leaders saying to me, wow, this is the most powerful training I think I've ever had in my 20 years as a leader. And they've been on MBAs, they've been on leadership programs, they've been on away days, they've been to international business centres. Yet they email us saying this is the most powerful training I've had, because we're suggesting to them they sit down and ask their employees how they feel. How did it come to the point that we're so fearful of asking our employees how do they feel, to then unlock the root cause of conflict, to create a system and a mechanism to resolve it? So if litigation is working, why have we got one of the lowest productivity levels in the G7? Now, obviously, it's not all about litigation. There are many factors. But for me, you can't resolve your dispute watching Homes Under the Hammer. You can't be productive. yet we suspend the individual for weeks, for months, for sometimes for years while we're investigating it. People go off on long-term sickness absence and stress as a result of this. That's not going to drive productivity. As I said, it's not the only factor in productivity, but I think it's a hidden factor that needs to be talked about and that a light needs to be shone on it. The UK is ranked 9th out of 12 of the leading industrial nations for employee engagement. I think some of the statistics suggest that only 30% of our workforce are engaged at any one moment in time. That's a lot of people disengaged. And I would again argue and suggest that the way that we deal with conflicts, disputes, disagreements are a cause of disengagement. I'll talk more about that in a moment. According to the Centre for Dispute Resolution presented at the CBI a number of years ago, research suggested that £33 billion a year is lost to the UK economy. According to the Chartered Institute of Personnel and Development, managers spend at least 30% of their time dealing with these issues. And OPP, the people who publish Myers-Briggs, estimate that 85% of your employees are dealing with conflict on some level. So it's there, it's ubiquitous, it's happening right now. We need to find a better way of resolving it. Because litigation, for me, it breaks down trust and impedes and inhibits the trust in the psychological contract. And as David McLeod and his partner Nita Clark from Engage for Success say very clearly, a breakdown in trust is the antithesis of employee engagement. Litigation breaks down trust as soon as we start to get into that mindset. So how can we then repair that and drive an engagement? As soon as we start to get that win-lose, right-wrong, blame, defend, attack mindset, it's undermining trust. Trust, communication and respect. Those three factors do a leap out of the nearest out of the nearest window. And it's very hard to bring them back again. But things are changing. This is Peter Cheese, the Chief Executive of the CIPD, who said last month, the HR profession is facing a shift in how we think about business. And this was very powerful from Peter because the CIPD have clearly, for many years, been saying to organisations, systems, policies, procedures, follow your process. When you get to an employment tribunal, don't worry, you'll be safe. That's what employment lawyers say to many of their clients. Have your policy, follow your policy. It's all about risk of aversion, risk management. Conflict resolution is not about risk management. It's about dialogue building. And what Peter's saying is we're moving past command and control and process-centric models that are bound by values and policies. And what Peter was advocating at the annual conference last month was a move towards a person-centered, values-based approach. And if the head of the CIPD is saying to the HR profession we need to move away, then I think real things can change. And I look forward in a moment to hearing some colleagues on this webinar. So finally for myself is we can't afford this to be happening in our organisations. Litigation costs an enormous amount of money each year. And I don't know many organisations in the current climate and looking towards 2017 who can afford for this to happen. So first poll for me, before I hand Camilla over to yourself, so I'll hand over to you in a moment, Camilla, but the first poll for me, just to get started, is looking ahead to 2017, do you anticipate that litigation would be a risk to your organisational continuity? So do you anticipate in 2017 that litigation will be a risk to your organisation? You've got three options. You've got yes, no and unsure. So I'll leave the poll open for a short while. So lots of people are voting now. Thank you very much. We've got a number of you are voting. Do you expect litigation to be a risk to your organisation during 2017? So 75% of you have voted. I'm going to close the poll in 10 seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. I will now close that poll and I can share the poll with you. So you should on the screen now be seeing the poll. Yes, I can see that you are seeing that. So 40% of participants on this webinar are anticipating litigation being a risk to your business during 2017. That's a lot of people. 20 of you don't anticipate litigation being a risk. Obviously, we'd be interested to hear from you during the webinar. And 40, you're not sure whether or not litigation will be a risk. But that's a really interesting poll. 40% of participants, and we have a number of participants on the poll, senior HR professionals, employment lawyers, and general counsel within organisations and senior business leaders. That's 40% of people are anticipating litigation being a risk during 2017. That's incredible, Camilla. So Camilla, I'm going to go back, apologies. Camilla, I'm going to hand over the screen to you. So if you just bear with me whilst I get the hand over the console to Camilla. Now don't forget everyone, please do ask any questions in the question box in front of you. So Camilla, I'm going to hand over to you now. You are unmuted, so Camilla, can you hear me?
Yes, I can, yeah.
Well, I can hear you clearly. Camilla, how are you?
Very well, thank you. Yeah.
Fantastic. Well, can I just say, Camilla, thank you so much for joining us today. I think, as I mentioned in the intro, we had a fascinating conversation. So I'm going to hand over to you now, and we're going to talk about your experiences of litigation from your perspective. So again, if you just set your screen up for screen share, that's go along a little bit, along one, two more. That's the one. Just press it again there, Camilla.
That should be it.
That's it. I think we can see it. You've got a box that says resume slideshow on your screen. Can you see that? Yeah. That's it. Okay. That should work now.
Okay.
Okay. Yeah. No, I think you and again, just press on the projector on the that's it. Just press on the icon again on the bottom there. It'll come onto the screen share. That's it. That's the one. It should.
It's disappeared under. It's disappeared.
Yeah, there you go. If you press it once, there you go. That's it. It should.
Okay.
It should appear as your. Okay, we'll just give Camilla a second. So again, Camilla is the Chief Executive and the founder of Yes Law. So just while she's getting her presentation is set up. So if you would like to ask any questions, we've got some questions coming through here. So I'll pose those to Joanna in a moment.
Well, let me, I'm trying to find the slideshow, but let me just start with just saying a few words about why, after being a litigating lawyer for 20 years, I gave it up, partly in discussion to set up Yes, getting to Yes, which never litigates and is focused on avoiding workplace disputes happening, and if they do, resolving them quickly and painlessly. So why give up litigation? The thrill of the chase, as many lawyers might say.
Yep.
I gave it up because of the damage that I saw it does to my clients and the distress that they went through, and really becoming, in many ways, unable to move on until the litigation was over. I think part of the problem is the employment law is now so complicated. So employers and employees need lawyers to interpret it. And the way the law steers parties down the grievance route, as you said, David, so on the track to the tribunal, really inhibits good communication between employer and employee because the fear of saying the wrong thing. And I think that is a real problem. I mean, our mantra is grievances do more harm than good. And I also, it's both employees feel they should do that, and employers, when faced with an issue raised by an employee, say go down the grievance route. Well, we all know that it rarely resolves anything, grievances, and I think that's one of the big things that needs to be changed. So I was going to start off with a few controversial, possibly controversial statements. I don't know whether you can see the slides now or whether they're not coming up still. But the first one, I would say, is that lawyers have no place in workplace dispute resolution except to advise in the background. And what we do at Yes is try and avoid lawyers being involved at all. The second point that we feel very strongly about is that legal threats are unnecessary. They are the first port of call for lawyers, but they really should be the last resort if the communication, the conversation doesn't solve things. And as I say, the fear of the law inhibits good communication. Employers are frightened about what they may say something wrong, which is going to land them in litigation. Employees feel the same. And as you say, David, the essence of a good relationship is where there's trust and confidence and communication. So what we would say, communicate, collaborate, consult. And And the focus in trying to deal with workplace disputes when they do arise should be looking forwards, not backwards. So, you know, the carrot, not the stick, the carrot of saying, let's try and resolve this, not the stick of litigation. And again, the way the law works and the way lawyers works, often to think, well, the only way we're going to get a good deal out of this is to make legal threats and to go over, rehearse the history of what's happened. And often that just entrenches the dispute. So those are slightly controversial. I'd be interested to hear people's views. So litigation, why I gave it up very briefly. At the beginning, I have to admit, I rather enjoyed it, like many lawyers. The joy of winning, the joy of the fight with the opponent, and the tactical maneuvers, and the challenge of succeeding. And as many law firms would say, or lawyers within law firms, the thrill of more cases and more targets to exceed. But it's pretty obvious, really, that not all cases are successful. And even if there is a win, it can be a Pyrrhic victory, because if it is a public hearing, the employee may find that it's going to be much more difficult to move on and get another job because there's been publicity. And there was one example of someone I acted for who won her case, who met an ex-colleague. I think she met her in the toilet and said, "Oh, let's have coffee. It'd be so nice to meet you." And the response was, "I don't dare. I can't be seen with you. I can't be seen having supported you." So I think it's very isolating. What's wrong with litigation? Well, we probably all know what's wrong and can agree. It is intrinsically adversarial. We reach for it too quickly at the expense of communication. We're always thinking, as often employment lawyers are always thinking, how do we protect our clients? And of course, that is really important. But I think one of the problems with lawyers sometimes is they're very, very risk averse, and so they tell their clients, that the employee clients, the employer clients, what they must do, instead of saying, how can we help you achieve what you want to achieve? There is an awful lot of lawyers playing litigations. There's the traditional 5-page threatening letter that arrives at 5 p.m. on a Friday afternoon. Deliberately so, and cost threats so that employees are fearful of taking the next steps. And the problem with this is it just entrenches again the bitterness between the parties and makes resolution so much more difficult. There's the refusal to engage with settlement until the door of the court. I had one case where we put forward a proposal right at the very beginning, and there was no engagement till the door of the court when the respondent offered exactly the same amount to settle the case. Many months later, with presumably huge legal costs. So good for the lawyers, but not good for their clients. And I think also that this stress and anxiety and distress suffered by clients, and I'm not saying that it is limited to employees at all, but one client, I saw a statement by her and then a statement by her husband, and both of them said, to my horror, our relationship will never be the same again after going through this litigation. And Camilla, you told me it would be stressful, but I never realized how bad it would be. And then there are the clients who say, I didn't get justice. The belief is that going to a tribunal will provide justice. Well, it's not always the case. In fact, it's often not the case. So it is a deeply unpleasant process, I would say. We need to move forward and find other ways for resolving disputes. And what we do at Yes is try and avoid all that uncertainty, conflict, stress, legal cost, reputational damage of litigation. And we do it a very different way, and 2.5 years later we have learned an enormous amount about how to negotiate. What we aim to do, we haven't quite succeeded yet, is to change the dynamic of the employer-employee relationship by focusing on constructive dialogue to find a solution. So often what we do is we pick up the phone, speak to HR and say, can we have an off-the-record chat to see if we can find a way forward? because clearly there is a problem here. So it's not about legal threats, it's about saying, let's talk together and find a solution. A lot of what we do is coaching parties to negotiate themselves in the shadow of the law, of course, which many employees say they feel empowered to be able to do that negotiation with some support and often get better results and, really importantly, maintain that good relationship with their employer, and so may get an amicable parting, which sometimes results in future work, i.e. a continued relationship. And just to highlight briefly why Yes, which is an ADR charity, is different. We do advise individual clients, employers and employees about their legal rights and obligations, unlike ACAS. We enable clients to resolve things themselves rather than through lawyers. So we always say, see if you can do it yourself. We find that the involvement of lawyers makes the negotiations more difficult. There tends to be slightly more aggressiveness. I'm not saying that's for all lawyers. We never ever litigate, and we always make this clear. But we also make clear that there is the possibility that the employee will litigate if resolution is not reached. We rarely make legal threats, and we work with mediators. If we can't pick up the phone and achieve resolution ourselves, then we would work with mediators. No one size fits all, but we work from the assumption that our strapline, life is too short to litigate, resonates with most people. It is simply not true that most employees want to sue their employer. They do not. Okay, yes, there are some, and they may end up in the tribunal, but the vast majority, what they say is, I don't want to be greedy, I want a fair outcome. They do not want to litigate. Of course, the adversarial system engenders conflict instead of communication. Most employees want to avoid conflict, and sometimes they come to us saying, well, I went to another lawyer, I was told, put in a grievance, and then you can bring a claim, and I froze. I really didn't want to do it. So we achieved a settlement without any litigation. And of course, most employers want early amicable solutions so they can get on with their businesses. It's really important, and we help employers sort out tricky situations in the same way. So litigation has to be there. It's the stick and kept firmly in the back pocket unless it is essential. And finally, what we'd like to see much more communication, collaboration, consultation between employers and employees. We'd also like to see a stage 1 mediation process which comes before the grievance to resolve issues. So there should be not ADR, but AIR, alternative issue resolution, airing the issues before the grievance. I urge anyone from human resources not to just say, put in a grievance. It doesn't help. It ratchets things up and makes settlement more difficult. I'd like to see an obligation on lawyers to discuss resolution at the earliest opportunity, not just go straight down the grievance litigation route. There should be a focus on constructive discussions, not grievances and legal threats, and a promotion of collaborative law to avoid the adversarial system, which is so damaging to the employment relationship. So just to finish, life's too short to litigate, isn't it? It's all about getting to yes. Remember the book about negotiations? Getting to yes, negotiating in a positive way and not litigating. And what I would say is it really does work. Our experience, many people say to us, how on earth can you negotiate a good deal unless you're going to threaten litigation? Well, I can say categorically 2.5 years later that you can, and the response is much more likely to be positive if you are positive and constructive, and litigation is the very opposite of being positive. So that would be my recipe for the future. Thank you very much.
And what a recipe it is, Camilla. That's a real call to arms, I think, is what I would call it. It was incredible, inspiring to hear you sharing your experiences of litigation and how you've got to taken the view that you have. So thanks so much for sharing. I think that shift towards a collaborative law model, which we've seen perhaps in the family courts being applied into the employment law, would make an enormous amount of sense to me. I think the shift towards an issue resolution methodology in organisations, for those of organisations who've done it, major banks and many others, they've seen a real shift. But Camilla, I've got a lot of questions that have been coming through as you've been speaking, so I'm going to try and respond to some of them. If you're okay, Camilla, just for me to ask you a couple of questions. I've got one here from Chizoma. There seems to be a culture of litigation by employees and an expectation that that it will be the first line of defence. And Chizoma would like to know, Camilla, how do we try to eradicate this as a cultural issue in organisations? I think you touched upon that in terms of the policies, but any thoughts or advice for Chizoma and listeners in relation to how organisations might adapt their culture to become less litigious?
Well, I think as you say, one of the big financial institutions has adopted a kind of mediation first procedure. So before any grievance is brought, the HR people or whoever within the organization are trained to sit down and say, what do you say we've done wrong? And let's talk about whether we can see if we can fix it. Language which is far removed from lawyers' language. And I also think that it's really important for those who instruct lawyers to make sure that they achieve what you want and don't just tell you this is what you must do to avoid any tiny risk. Because employees and indeed employers respond much better to that constructive discussion rather than involving legal rights and obligations.
Thank you very much, Camilla. There you go, Chizoma. Hopefully that's answered the question. It's a big question in relation to culture, because our society, our justice models are based on hundreds of years of adversarial justice. It's embedded deeply ingrained into our organisation's culture and our society in many respects. So we're talking about significant culture change where justice can be done by two people sitting around the room and having a conversation, as much as taking our case to a higher authority for a determination, whether that's through a judge or a jury of our peers. So I think the word culture is a big question. Camilla, we've got Adrian, who's asked a number of questions. He's asked 3 or 4 questions, Adrian. I'll try and, if I can, encapsulate. I think, would it be fair, Adrian, to say that you can see the value of mediation, but you're sceptical, perhaps cynical, I don't know if that's the right word, of how far mediation can be used. And you mentioned the Southern Rail dispute. If all sides are so polarised, then you ask, how could mediation help? I mean, Camilla, what would you do if you were handling the Southern dispute? That's a big question, but how would you go about solving their differences? If we could give you a magic wand.
Well, they may have done this already, but I'd get them into a room all together with individuals as well who, on either side, who are committed to resolution.
Yeah.
So what you need in the room is you need the advisors, whether they're lawyers or not, really wanting to sort it out, and that their reputation is based on sorting it out. And I think that is really important, and that is part of the culture change.
Yeah.
I also think that it is important to acknowledge when the employer, or indeed possibly the employee, has done something wrong, to address it. In a way, you don't need to admit to having done something wrong, which is, of course, what the lawyer would say. Don't admit you've done something wrong, and if you apologise, that's an admission. You can make an apology, which is not an admission. And I think there should be much more of that acknowledgement of, okay, we could have done this better, but what we want to do is, sort it out now, and how can we sort it out now, because it's in no one's interest for this to go on.
Absolutely. I remember, Camilla, when I was in 2009, I was regularly on Sky News, on the GMTV sofa, on BBC News, commenting about the Royal Mail dispute one day and the BA dispute. I don't know how I managed to become like the regular commentator on dispute resolution on those news channels, but I remember it was often involved getting up very early to discuss industrial relations issues. And the BA and the Royal Mail were the basket cases of British industrial relations. In the last 2 years, Royal Mail have not lost a single day to industrial relations dispute, and BA the same are well out of the news. And why have they done that? BA and Royal Mail have both embedded a mediation culture within their organisations. And Royal Mail Group in particular have a legally binding agreement, Adrian, between the CWU union and between the managers that they will go to mediation first. They have a mediation panel internally, they have access to external mediators where they're required, and they haven't lost a single day to a strike in the last 2 years, saving well over £6 million a year is some of the figures that I've been hearing. It takes guts, and I think it takes real guts for the Southern Train management and for the unions to get back around the table. Waiting to go up to Euston Tower to ACAS to wave a piece of paper in the air is old-fashioned, outdated, outmoded industrial relations. You ask how mediation could work. For me, I would be sending a mediation team, a turnaround team, down to Southern Rail. I'll be talking to all of the key players, and the process cannot just happen by a few days in Euston Tower in front of the glare of the media. It takes weeks and months of careful, quiet diplomacy, bringing the parties together, moving away from the brink and slowly building trust, respect and dialogue. And I think there's a risk in our fast-paced, fast-moving, we want answers tomorrow society that we lose sight of the slow diplomacy that's required. But unless that happens, the impact and the misery on real people's lives will not end. So I would be calling on Southern Rail, I'd be calling on managers, I'd be calling on the government to do something now, to build a troubleshooting team and get down there and have the kind of conversations that we're having across the NHS, across Royal Mail, across other organisations, that really does work and really can change people's lives. Things can be done. We can't just accept the status quo because it is the status quo. That's certainly not an option. Sarah, one more question, Camilla, if I may. It's a really good question, Sarah. Thank you very much, Sarah Bealey. So how do you encourage, Camilla, the other party in a resolution to give up their lawyer? Great question.
Brilliant question, yes. Oh dear, you're probably not going to be able to do that. It has been known, I think, occasionally to suggest that the two individuals, the employer and the employee, have a chat together to see if they can get anywhere. And I think that's maybe one thing, but you've got to persuade the employee that you're not going to try and trick them. And if they've got a lawyer who's kind of into litigation tricks, that may be more difficult. But I think it is worth trying to have that conversation. I mean, I'll just give you one example of where we got rid of a lawyer when we were negotiating for an employee about a restrictive covenant. We couldn't understand, the employee and I couldn't understand what the problem was. So I said, just go and talk to your boss. Not what you're meant to do if you know if the lawyer's a lawyer. Went to the boss, and the boss said, well, we thought it was rather tough, but this is what our lawyer told us to do. So anyway, it sorted things out. I'm sure Joanna will have much more to say.
Well, on that great segue across there. Thank you very much, Camilla. Camilla, thank you so much. And I'm looking forward to working with you in the future. And of course, you're contributing to the book I'm writing on managing conflict for Kogan Page, and we've co-authored a blog which we put out on our websites and on LinkedIn. So I'm looking forward to continuing to work with you. Let's move on. Joanna, I've unmuted you. Can you hear me, Joanna?
I can hear you, yes.
And we can hear you loud and clear. Welcome. Thank you very much, Joanna, for giving up your valuable time today. And I'll hand over to yourself to introduce you, but you're an employment judge with the Central London Employment Tribunal, I understand, Joanna.
Yes, that's right. I am. I was a solicitor and have worked in the past with Camilla, whose work I absolutely, utterly respect, and we share nearly everything she said. I completely agree with. It's an interesting perspective, though, looking at a conflict from the viewpoint of a judge, because of course we see both sides locked into this dispute that we so often profoundly hope they could have avoided. And of course we do mostly from our perspective provide justice, but 50% of the people who come before us don't agree. And of course, if you lose, what do? You almost always blame the judge. But I think I think Camilla's completely right in saying that winning is almost as bad as losing, and it's particularly probably totally disastrous if someone is still employed in the organisation during the litigation. So if anything can be done to avoid litigation, it is highly desirable. Of course, rights are important to people, and Camilla used the phrase the shadow of the law. The fact that some people assert their rights makes life better for all those operating in that shadow. And if you are badly wronged, or you perceive you've been badly wronged, you need to do something to make yourself feel better. And whilst probably time is the best healer, it's a difficult thing to roll over and slink away when you feel you have been wronged and you feel very bad about it. So I understand completely why people litigate, and I think our job is to try and help people find a way out. And I think the more I think about this, the more I think that managers have got a fundamentally important part to play. It's easy to perceive the employee as obsessed with their rights and as prone to litigation. But often, of course, managers are people too, and their sensitivity to being criticised and potential insensitivity to the struggle that an employee is having in the workplace, I think plays a huge part in triggering what then becomes a very toxic dispute. And there's usually a germ of something having gone wrong, and usually that germ has been germinated by both sides. And so I think that managers would do well to try to give people a way out, a decorous, honourable way out of the problem, and to do that at a very early stage. And of course the other problem is that not everybody, for psychological anger reasons, because their family are telling them don't let them get away with it, you've got rights, etc., etc. For all sorts of reasons, the airways are blocked with anger. Not everybody is able to sit down immediately and engage in constructive dialogue. And the challenge, as David said, for the mediator is then to try and find a way out of the conflict, or some small seed that helps to explain why the situation has got so bad, which may not be immediately obvious. People may not be able to articulate what is wrong, and those, of course, are the particularly challenging situations. And you can go down blind alleys. You know, you get a lot of people saying, I've been badly treated because of my sex or my race, and actually that really isn't the problem. There's no point in just keeping a closed mind to where the problem may lie. We legalize a problem by giving it a legal label, but often it's far more generic than that. Just a couple more things to say. I think David again is right to mention family law. I think fundamentally, and I'm sure Camilla agrees with this too, employment relationship is a relationship. In fact, it's probably the closest relationship you've got to your spouse. It's where you spend most of your waking hours. And while family lawyers have really got the idea of mediation, it's embedded in the divorce system, we absolutely haven't got it. And I think there is work that can be done amongst employment lawyers to try to encourage the idea of a more mediation-focused approach. I think two more things to say. First of all, I do think there is a problem with some lawyers who it's simply not in their interests not to protract matters, and their involvement will exacerbate. But again, as a manager, you have to turn the other cheek and be broad-shouldered about it, because a lot of people simply don't know that going to a lawyer is not the right thing to do. They don't know that they're being confrontational. They think that what they're doing is standing up for themselves. And the other thing to say, I think, is that in my many years as a solicitor and then as a judge, I have so rarely heard an employer say sorry for anything, any small thing that has happened. And when I have seen that happen, it has so fundamentally changed the atmosphere of the discussion. So I would challenge those of you who are employers listening to this webinar, I suspect most of you, to dare to admit to failure occasionally, and or to dare to admit to having gone about something the wrong way. I think it makes a huge difference. Thank you.
Joanna, thank you, and I think what you're asking for is for people to be able to show courage. I mean, the challenge, Joanna, is, if we have a bump in a car and I run into someone in on an icy day going up to a giveaway junction, my insurance company and lawyers have told me, do not apologise, don't accept culpability, and that seems to me to be something that permeates not just through the drivers of the world, but also through organisations, and that by apologising or accepting that there are errors that have been made, or I talked about failure early in the session, that in some respects I'm showing weakness and I could be making myself culpable. And so I'm really interested in just if we can just tease that out a little bit in terms of how might an organisation, how might an employer accept that things didn't go right for whatever reasons and offer a meaningful acknowledgement and an expression of regret in a way that doesn't then cause problems down the line.
Yes, well, it's a very easy answer because something often has gone wrong, as I said. So you will have done an appraisal but failed to communicate the mark to the employee, or you'll have forgotten for a couple of months that they're due a bonus, or you'll have left them off the guest list for a staff meeting. And that will be a small canker that will start to grow, and you'll have an employee before long, quite often happens, who will start to say that you're discriminating against them because of their age or their race or their sex or whatever. And you can absolutely apologise for the thing that started the problem, which was leaving them off the guest list or failing to communicate the appraisal mark to them. And in fact, you're bolstering the strength of your case by doing that, because you're showing that something did go wrong that had absolutely nothing to do with their race or their gender. So you're nipping in the bud, the canker, if that's not a mixed metaphor, which it is, the problem.
I think
and you're actually bolstering your defence in the process.
I think plants do get cankers as well, so I think I don't think you necessarily were.
Oh, maybe not. I hope not.
There was a little bit of a mix-in, but I think it was still on the on the side of things. No, John, I think that's really interesting. We've got a couple of questions here. So, Sarah, thank you. You've asked a couple of questions. One of them, Sarah's asked here, is in relation to training HR professionals and lawyers, and Sarah's suggesting that we ought to be getting in a little bit earlier into universities and colleges. Any thoughts, Joanna, about what the universities and colleges can be doing, and the law schools, of course, could be doing to promote a change in thinking amongst the legal profession and HR profession as well?
Well, I think one of the problems actually is that employment law, I think I'm right in saying, isn't on the curriculum of most universities at undergraduate level. So which is sort of a shame, because it's so important. I think that it's a really good point, and I think that actually academics who are often left out of these kind of discussions should be involved in discussions about that when they teach the fun of, as Camilla said, the excitement of a law case, a victory pulled out of disaster, that actually they need to be a little bit more careful with how they present that. I think that's a really good point.
Thank you. We've got lots of questions, Ryan. I'm conscious of time. This is great fun talking with you and having your insights, and I think you've definitely causing people to think and come back with more questions. But so we've got questions. We will have an opportunity to try and respond to those in the paper that we'll be producing. But Joanna, I'd like to just say again, thank you so much for sharing your insights and thoughts, and thanks for taking up the time today to join the webinar. I hope you'll stay online and listen now to David. David, are you there? Let me just...
I'm here. Can you hear me?
I can hear you. So let me just give you control of the screen, David. Sorry, we're running a little bit over time, everybody. These participatory sessions do take a little bit longer because obviously there's the questions, but I hope you'll stay if you can now and just listen to David Parry. As I've mentioned, he runs David Parry Employment Law, someone I've known for many years. And David, I've given the screen over to yourself. So without further ado, shall I hand over to you, David? And thank you very much for joining us this afternoon.
Please do. Thank you. Hopefully you can see my my slides that are up, are they?
Yeah, they're clear. I can see those fine.
Excellent, excellent. Well, thank you very much indeed, David, for the opportunity to participate in this debate today. I would endorse much of what Camilla and Joanna have said. My approach over the next 5 minutes or so is just to give a few examples of my personal perspective, how I got into workplace mediation in the first place. So I've been a solicitor for 25 plus years. So I specialised in employment law throughout that period. Until 3 years ago, I was head of a regional firm based in Oxford. And 3 years ago, I set up my own niche practice in Witney in the lovely Cotswolds. And my road to Damascus moment, which I've described here on the slide, is probably about 15 years ago. A client of mine, an employer client, emailed through a tribunal claim form, and it was a 4 or 5 page dialogue of complaints against the employer. And I know there's always two sides to a story, but I was looking at the complaints that were being made, and I thought, gosh, this doesn't look good at all. I went to see my client, and an hour and a half later, heard the other side of that story. And the lady, the complainant, was worked in the sales team, and the complaint scope went back for a couple of years, and it started on an incident which to the outside world would appear very trivial. I think the boss didn't say good morning to her or something. It was something that trivial, and anyway, the relationship got worse. She started complaining about her boss. He started performance managing her. Eventually, she resigns and claims constructive dismissal. Anyway, I said to my client at the end of this meeting, I said, gosh, this does sound terrible. What was she like before all this happened? Oh, she was our top salesperson. And I was astounded. I thought, well, surely if someone had got in there at a very early stage to resolve this problem, this person would never have left. They would never been in the tribunal, and they still have their top salesperson. It was at that moment that I came across the concept of workplace mediation, and I got in touch with a wonderful organisation called TCM and David Liddell, and I trained as a mediator through them. So my focus on workplace mediation is more on resolving conflict in the workplace rather than at a tribunal. As Joanna said, I think you know, by the time the parties got to tribunal, the relationship is over. So as I say, my focus is on resolving conflict in the workplace. So while litigation is often not the best outcome for anyone apart from the lawyers, in fact it goes in slightly earlier than that. Why grievance procedures are often not the best outcome. You have employee A who makes a complaint about employee B. Manager C has to listen to that complaint and make a decision. And regardless of the outcome, the decision, you know, employee A is right, employee B is wrong. Employee B is going to be left unhappy. So the whole point of mediation, as we all know, is that the parties in conflict, in dispute, try and resolve the matters for themselves. I spend a great deal of my professional life advising people not to go to tribunal unless they absolutely have to. Of course, there's the cost, the stress, the inherent risk of litigation. But an important aspect from the individual's point of view, I find, is that they spend the next 6 or 12 months, however long the tribunal claim lasts, looking forwards, getting more angry, more bitter, more entrenched in their position, rather than what they should be doing at this time, which is looking forward, doing their best to try and find new work elsewhere. Then I advise them and I say, well look, even if you go to tribunal, even if you win, does that help you get another job? Well, no, it doesn't. New employer says, well, how did you lose your last job? Well, I was dismissed, but it was unfair because the tribunal told me so. Well, that's not going to help them get another job elsewhere. The final point that I would make is headed the duty on employment lawyers to promote workplace mediation. Now, for those lawyers who may be listening today, of course there is no such duty. The duty is to act in the best interests of your client. Now, I can think of many cases where, as an employment lawyer, if you're rung up by your client, whether it's an HR manager from a large organization or the owner of a smaller business, where grievance just landed on that person's desk, then yes, you can advise them on how to go through that grievance procedure. But have you thought about saying, well, would mediation resolve the issue? And in many cases, it would do. And so, therefore, in my opinion, the employment lawyer who doesn't raise the concept or the issue of mediation with their employer is not, in fact, acting in the best interests of their client. And the final point I think I would make is that I see many grievance procedures from all different types of clients. Very rarely do I see, most grievance procedures talk about how in the first instance we will try and resolve matters informally. Very rarely, if ever, do I see a grievance procedure which says, and we will invite the parties to go to mediation before going to the formal part of the process. If that was embedded into the procedure, then I think there'd be a much greater take-up. So thank you. Those, David, are my points.
David, thank you so much. That road to Damascus moment was great to hear. What a great experience, and what a powerful and high impact and recognition of the value that mediation can play. And I think it's great to hear you talking from an employment lawyer's point of view, because in essence, you're a gatekeeper, I think, David. And if the more that yourself as an enlightened legal professional and others in the gatekeeper role can steer people towards a collaborative, consensus, dialogue-based approach, then that drives the cultural change. And it does happen one case at a time. It has to happen one case at a time. But I also think you're right to say that we can also be changing the way that our grievance procedures are written, and perhaps introducing procedures such as the resolution policy, which does offer an alternative to grievance procedures. To grievance processes for organisations. And as I mentioned at the start, if anyone would like a copy of that, please do let me know. But David, thank you so much. I didn't realise the time is flying by, David. So are you okay if we move on and begin to close the session down? And what I would suggest we'll do is, if I'll happily stay on the webinar for a little while now, to answer any questions, and if anyone else, David, if you're able to, or Camilla, or even Joanna. But I'm going to draw the session to a conclusion now, because I think we're well over time. But David, can I just say a huge thank you again for participating in this webinar today.
Pleasure. Thank you, David.
Thank you very much. So, coming to the end of the session today. So thank you very much to our speakers, to Camilla, to Joanna, and of course then to David. I hope that you can see my screen okay. I'm just looking at it. It should be shown as a clean screen. So I'm just going to put the final of the polls up. Is have you found today's webinar useful? Have you found it very useful, quite useful, not useful, or you've wasted a valuable hour of your day that you'll never get back? So have you found it very useful, quite useful, not useful, or a waste of a valuable hour that you'll not get back? So I'll keep that open. Welcome your feedback. And of course, if there's anything that we can be doing to make our webinars more useful to you, we offer these free of charge. And to hear an employment lawyer, to hear a QC, and to hear a judge talking in a conference, we might be looking at £200-300 of sitting in a workshop for a breakfast seminar or for a half-day workshop. This is provided free of charge by the PMA in partnership with the TCM Group and Yes Law and other partners, David, Parry and Joanna, to give you the information to help you make the decisions about how you'll handle conflicts and disputes in your organisation. So I'm going to close the poll now. 5, 4, 3, 2, 1. So I'll share the results. So 42% have found it very useful, 51% quite useful. So I make that a total of gosh, my maths is terrible, 93% have found it either useful or very useful, and 7% unfortunately not found it useful. If it's not been useful to you, please do let us know. How can we make these events more effective, more useful for you for the future? We would love to hear from you. But life's too short, Camilla. You're right. Life's too short to litigate. We've got a lot of challenges going on in our lives at the moment for one reason or another, and litigation drives sadness. And one of the things that occurs to me when I'm working with people in a conflict or a dispute is just how sad they are. So let's try and address that. I think we can be happy. Happiness can lead to healthiness. Healthiness can be productive. And I would suggest that a happy and healthy and productive workplace can drive economic growth for our organisations and actually help us to deal with some of the challenges, particularly post-Brexit, in helping us to drive economic advantage. So thank you so much, everybody. Thank you for joining us. Please do tell your friends. Join the PMA if you wish. It's free of charge. professionalmediator.org. Just simply go on, put your application in, and you can become an associate member of the PMA and benefit from everything that the PMA offers. But for now, thank you so much. Please do send me questions. If you want a free copy of the TCM resolution policy, it's in place in Lloyds Bank. Royal Mail have been adopting it. Kent County Council have been adopting it. Organisations are adopting this approach now as an alternative to formal grievance and disciplinary processes. And wow, it's having an impact. Please do email me. I'd be delighted to share it with you. And I'm all over social media. There are my details. I'd love to talk with you in person, of course, and in cyberspace. But for now, I'm going to say a thank you very much. I'll stop the webinar now and look forward to welcoming you to our next one in the new year, and wish you a very happy Christmas in between times. Thank you very much.
I think it's a big mistake if they're getting paying for advice from lawyers. They'll just be paying a lot more, and the complaint will go on for longer. And sitting down and having that conversation, I mean, just having the conversation is just so important and can stave off a lot of grievances, and I believe litigation as well.
Absolutely. So I think so. I'll just letting I press recording. So I think these questions will be quite useful for the. Well, I think we've run out of all the questions, but I just pressed record there halfway through because I thought if we get these typed up for the white paper, it might be quite useful. If anyone else has got a question, please do. There's still 21 people on the webinar, so we've lost a lot of people. We had over 150 registered for this webinar, so it's certainly one of our big events. I'm attending a forum and leadership in Manchester, says John. John was asking what would be the best way to introduce the benefits of mediation as a leadership skill. So that's a good question. I'll probably go back to John. But any thoughts about how our leaders and managers could be doing this on a day-to-day basis and the skills they could be using from your experiences, David and Camilla?
Well, I'd direct them to you, David. You obviously, this is what you do. You train organisations, managers within that, how to resolve conflict outside of a formal process. It's training in its culture.
It is.
The other thing I'd say.
Go ahead, Camilla.
The other thing I'd say. So many employees came to me to say, if only my employer had talked to me at an early stage, I would not be sitting here now. So I think the importance of listening to what the employee is saying and really having even if it's criticizing the manager, trying to sort it out, trying to explain, and you know, as we all say, saying sorry, and that will, employers would keep many more valued employees if that was the policy they adopted.
Absolutely. I think because the apology, there's a great book called The 5 Languages of the Apology. I can't remember the name of the author, but I'll dig it out and send it across to people. And in that, we talk about apologies, because people often want an apology, but what it's often is an expression of regret, an acceptance of responsibility, an expression of remorse, and some form of a reparation. And I think an apology, some people see as a sign of weakness, is to apologise is to be weak and to be, in some respects, giving something up. But in actual fact, by apologising, allows the other party to acknowledge the apology, to forgive. And I know forgiveness is, I talked about feelings being the F word of the modern business, and forgiveness, because of its sort of quasi-religious terms in some respects, forgiveness, is it's not talked about, but it allows people to forgive and move on when they have an apology. They also get some really psychological benefits. They get an understanding and an appreciation of the issues. They get the feeling of being heard. There's the cathartic benefit. And that issue for me, when I'm talking to people, either pre or post litigation, they often say to me, David, all I want to do is for them to listen to me. They realise often that they've maybe done things wrong themselves. This is the interesting thing that fascinates me. People often recognise that they haven't always behaved in an appropriate way, and they recognise that. But because of the polarised nature of litigation, they themselves are willing to accept responsibility. But when they're talking to me privately, that they are happy to do so. So I think what we're offering there by having the dialogue and a chance for an apology, it allows people to move on and move forward and gather learning. And I just think litigation, whilst it clearly has its place, it doesn't drive what you call a learning mindset or a learning organisation. And I think managers can be doing that far more effectively and doing so much more to drive that kind of... Well, look, I think we've probably come to... Sorry, David?
So can I add one point to that? You see this all the time in sexual harassment cases. Very, very often, the individual who's complaining, and more often than not, it's a woman. She doesn't want the person to be disciplined. All she wants is the behaviour to stop and to be able to get back to work again. What happens in practice is she's encouraged by HR to put in a formal complaint. That then goes under the bullying and harassment procedure. The person then receives the notification of that, and the party positions then become entrenched, and it's almost impossible to sort it out. You see it time and again.
Absolutely, and it's really, and they almost get pushed into a form of process that isn't what they were looking for, and that creates its own stresses, I think, for people. You know, and in some respects, mediation or ADR, it's like, you know, on an escalator that's running out of control. It's like a big stop button. Is please help me get off this. And people, again, there's a psychologist, Martin Seligman, great psychologist. He was one of the founders of the School of Positive Psychology, sort of drawing on appreciative inquiry in particular. And he says very clearly that a loss of control is one of the biggest causes of stress and anxiety for human beings. So if, as you're rightly saying, people don't want to go down that formal route, but in essence they kind of are corralled into it for one reason or another, they're giving up control, and in so doing they're actually putting them at greater level of stress and anxiety. And people often think sitting in a room will be the most stressful and angst-ridden thing they do. But I'm sure as mediators you've seen it, the people come out of the other side and go, wow, I never expected it to be like that. It was far more effective than I expected, far better than I expected. It was nowhere near as bad as I expected. I wish we'd done that earlier. And that's the overarching message, I think, for me to give to people is, I wish I'd done it earlier. Well, let's do it earlier. Let's give people a chance to get into a room. We can't force them to get into the room. We wouldn't want to force them to get into the room. But we can make mediation the preferred route to resolution for people. So Camilla, David, Joanna, thank you so much. Thank you for the 20 or so people who've stayed on. I hope this bit of a Q&A at the end has been useful for you. Look, we're just wanting to have a debate and a discussion here. There are no absolute rights and wrongs, and I hope this has contributed to it. I think the guest speakers have been fantastic. I hope that we can have more of these kind of conversations, and who knows where this might go. But for now, thank you, everyone. I'll close the webinar off now. And again, if you have any questions, you can see my email address hopefully now at the bottom, Sue, at the bottom of the screen. But I will send out a follow-up email. And I've had a few requests for my resolution policy. Do let me know if you've got questions or want anything. But David, Camilla, everybody, thank you all so much. And have a lovely Christmas. Cheerio. Bye.
Thanks.